Hello again. Welcome to the second podcast in Module 6, Child Abuse and Child Protection. In this podcast, our focus will be on the Child Protection Act 1999, Queensland. This Act is available for you through a direct link on the learning page for this module. Just by way of overview, this podcast will deal with the circumstances in which a court will make a child protection order and examine some of the types of orders available. It won't be possible for us to work through every part of the legislation in this podcast. What we are going to do is to introduce you to some core concepts and look at some of the basic requirements. Before moving on, I should mention some terminology. This Act uses the terms custody and guardianship. The terms live with, spend time with, communicate, and parental responsibility that you have seen in the Family Law Act are not generally used in this legislation. Just a note also about who is the applicant and who is the respondent. If there is an application under the Child Protection Act, then a representative of the Director-General, Department of Communities, Child Safety and Disability Services is always the applicant. A private person cannot make an application to a court for a child protection order. Section 10 is important of the Child Protection Act as it provides the jurisdictional basis on which the department can take steps, including making an application to a court. A child in need of protection is one who has suffered significant harm, is suffering significant harm, or is at unacceptable risk of suffering significant harm, and note the and is particularly important, does not have a parent able and willing to protect the child from harm. Section 8 says that a child is any individual under the age of 18 years. The next question is, what is harm? Section 9 defines harm as any detrimental effect of a significant nature on the child's physical, psychological or emotional well-being. It is immaterial how the harm is caused. Harm can be caused by physical, psychological or emotional abuse or neglect, or sexual abuse or exploitation. Harm can be caused by a single act, omission or circumstance, or a series or combination of acts, omission or circumstances. You will see when looking at the Act there are a number of provisions that deal with mandatory reporting, urgent steps, temporary assessment orders, court assessment orders, temporary custody orders, case planning, intervention with parental agreement, and family group meetings. It is worth your time taking a look at some of those sections. They are, however, outside the scope of this podcast. Our focus will be on the circumstances in which a court can make a child protection order. An application for a child protection order is made to the Children's Court of Queensland by a representative of the Director-General of the Department. Section 57 sets out that the child's parents are the respondents to the application. The Children's Court may only make a child protection order if it is satisfied that 5 requirements have been met. The first, in Section 59, subsection 1, paragraph A, is that the child is a child in need of protection and the order is appropriate and desirable for the child's protection. Second, and this is set out in Section 59, subsection 1, paragraph B, the court must be satisfied that there is a case plan that is appropriate for meeting the child's assessed protection and care needs, and if it is proposed that the order deal with long-term guardianship of the child, that the case plan includes living arrangements and what is described as contact arrangements for the child. The balance of the requirements are set out in sections 59, subsection 1, paragraph C through to paragraph E. They are that if the making of the order has been contested, a conference between the parties has been held or reasonable attempts to hold a conference have been made, or because of exceptional circumstances, it would be inappropriate to require the parties to hold a conference. In this context, conference means a conference between the relevant departmental officers and the parents to see whether the matter can be resolved by consent, and also to develop an appropriate case plan if necessary. The last two requirements are that the child's wishes or views, if able to be ascertained, have been made known to the court, and the protection sought to be achieved by the order is unlikely to be achieved by an order on less intrusive terms. There are 6 different categories of order that a court can make. These are set out in section 61. They are A. An order directing a parent of the child to do or refrain from doing something directly related to the child's protection. B. An order directing a parent not to have contact, direct or indirect, with the child or with the child other than when a stated person or a person of a stated category is present. C. An order requiring the Chief Executive to supervise the child's protection in relation to the matters stated in the order. D. An order granting custody of the child to a suitable person other than a parent of the child who is a member of the child's family, or the Chief Executive of the department. E. An order granting short-term guardianship of the child to the Chief Executive, or F. An order granting long-term guardianship of the child to either a suitable person other than a parent of the child who is a member of the child's family, or another suitable person other than a member of the child's family nominated by the Chief Executive, or the Chief Executive. I've set out those requirements again for you on the slide. There are some extra requirements for a court before an order can be made for long-term guardianship. Those requirements are set out in sections 59, 6 and 7. The court must be satisfied that there is no parent able and willing to protect the child within the foreseeable future, or the child's need for emotional security will be best met in the long term by making the order. The court must not grant long-term guardianship to a person who is not a member of the child's family unless the child is already in the custody or guardianship under the existing order, child protection order, or the Chief Executive can properly grant guardianship to another suitable person. There is one procedural matter to mention. Section 110 provides that if the Children's Court considers it is necessary in the child's best interest for the child to be separately represented by a lawyer, the court may order that the child be separately represented by a lawyer. The obligations of a separate representative's role is very similar to that of an independent children's lawyer in family law proceedings. Those obligations will be dealt with when we consider children's views in Module 7. For these purposes, be aware that the obligations of a separate representative in child protection proceedings include attendance at family group meetings and throughout the case planning process. Their role ends once a final order is made by a court. Thanks again for listening to this short overview of the Queensland Child Protection System. Next, I'll take you through the relevant provisions of Part 7 of the Family Law Act 1975 and the concept of abuse and how it's dealt with throughout that Act. Thanks for listening. Bye for now.